let me introduce myself. I'm Grant Nelson, and I'll be moderating this panel. We have a distinguished panel, and it breaks down logically into two topics, property law and contracts. And so what we propose to do is to have Professor Helmholtz and Professor Opterbeck each talk about 10 minutes apiece about property, and then we'll have a 20-minute question and answer session. And then after that, we are going to have a two-person panel on largely contract law with Joel Nichols and Scott Pryor. So let me introduce our first two panelists. Richard Helmholtz from the University of Chicago, very, very distinguished professor who I had the good fortune of being able to use a lot of his materials over the years when I've taught remedies and property law. He's really a giant in his field. And then we also have David Opterbeck from Seton Hall University, who is a top-notch scholar in intellectual property and related matters, and also law and religion. And we'll start with Professor Helmholtz for 10 minutes.
Sorry.
Oh, I'm sorry. You want to go first?
He's first.
Okay. We'll start then with Professor Opterbeck for 10 minutes, and then we'll have Professor Helmholtz for 10 minutes, and then we'll have a 20-minute question and answer session.
Great, thank you. So thanks to Bob and to Pepperdine. This is a great conference. It's really fun to have so many enlivening conversations with all of you, both in the sessions and at lunch and other places. So I'm really grateful to be here. And my presentation really, and the paper that I have on the website really tries to be kind of a synoptic chapter, which would be part of a larger book on Christian thought and private law, and so I'm doing this kind of piece on property law. So my overall chapter is really intended to be kind of a broad summary. I initially titled this talk sort of From the Margins, because I want to bring a little bit of that emphasis into it, although I'm also going to do a bit of the synoptic stuff in this talk as well. And I think property law is a really interesting category and difficult category for Christian thought, a challenging category in a number of ways. I have this quote here from Jeremy Waldron, and I think it intuitively makes sense. Our notions of property law, of why we have property law, revolve around this concept of scarcity. And whatever sort of moral, economic, other kind of justification of property you might come up with, it's going to revolve around this question of scarcity. But that raises this issue, why is there scarcity? And particularly from a Christian theological perspective, why would we have this notion of scarcity? And to me, one of the really interesting things about all this is to look at sort of the origin stories or the origin narratives that frame our concepts of property. And I would suggest that sort of post-Enlightenment, the kind of intellectual heritage that our Anglo-American jurisprudence in many ways has inherited, it's based on the idea that the state of nature is a state of scarcity. We can find this in Hume, we can find this in Locke, we can find this in more contemporary sort of scientific accounts. So the state of nature is a state of scarcity. But of course, in biblical thought and in the Christian theological narrative, the original state, the state of creation, is not a state of scarcity. It's a state of abundance, it's a state of fecundity. It's a state where everything that is necessary is provided. It is, as we've heard kind of throughout the past couple of days, other people talking about that narrative, it's a state in which human beings are given work to do and are expected to do work, but there's not any sense in that there's a possibility of starving or not having things and not having your needs being met. And so in the biblical and Christian narrative, I would suggest, scarcity, or at least misallocation, is a result of sin. And that's a very different kind of origin narrative than the kind of narrative that supports our usual concepts of property. Further, this sinful aspect of scarcity or misallocation in the biblical tradition, in the biblical prophets, and in the Gospels, and Jesus also speaking as a biblical prophet, they're deeply invested in this problem, in this issue of misallocation or scarcity, and the fact that it derives from different kinds of ideas that we would call sin. So I'm just going to look real briefly at a few pieces in the scriptures, just, as we've been doing, a number of people have been doing, just pulling out a few things, only have 6 minutes left, but a few things I would want to emphasize. If we look at the Hebrew scriptures, I think when we look at the biblical law in the Hebrew scriptures, there are some really interesting ways in which that law deals with the question of property. One of the pieces I find really fascinating is that the entire property system in at least the Levitical and Deuteronomic law is really kind of clan-based, and there are some very specific rules against alienation, really to prevent problems of misallocation. So for example, here's a portion of the Levitical law that talks about providing for the redemption of the land, this idea that you can't permanently alienate the land. Just a quote here from biblical scholar and theologian Christopher J.H. Wright, who talks about the notion of kind of speculating and amassing large quantities of land, at least under his reading of these rules, would be really technically impossible, it'd be legally impossible. And the law is, one way to look at it is the law is kind of set up for that very purpose. Then the Hebrew scriptures, we have other sort of examples we can talk about. Of course, the gleanings laws, various prophetic texts that are substantially about misuse of wealth and property. And then we have some ambiguity because we have the wisdom literature, and there are parts of the wisdom literature that sort of talk about wealth and the accumulation of property as a blessing, right? So there are various aspects we can see in the Hebrew scriptures. In the New Testament, we can look at the Gospels, and of course, famously, one of the things Jesus talks about often is wealth and the accumulation of wealth and the issues of wealth and poverty. One famous example, of course, the rich young ruler. I've kept the law, what else do I need to do? And Jesus tells him, sell all you have and give it to the poor. And of course, there are a variety of interpretive traditions about exactly what that parable means. There's also the parable of the rich man and Lazarus, these different things of Jesus talking about wealth. And here's this invocation that Jesus gives to the rich young ruler. Sell all you have, sell your possessions, give to the poor. And then, if we kind of pick up the story in the New Testament, in Acts 4, we see the early church, and there's this text that indicates that the believers are sharing all of their goods with themselves. And I'm just putting some of the Greek words up here, not because I think they're sort of technical theological words, but what I think it illustrates is that the Acts 4 community as pictured is actually fulfilling what the rich young ruler could not. So that the notion that you are actually giving away your goods, you're divesting yourself and you're sharing among yourselves, is at least in this period kind of seen as a communal norm. There also is an element of prophetic judgment in the New Testament. To me, one of the most fascinating passages in all of the New Testament is this text from Revelation 8. And I think it's fascinating on a bunch of levels. Just historically, it's the author obviously has a knowledge of commerce in his day, obviously had been around port cities in his day. And he talks about Babylon the Great, maybe a reference to Rome, but a broader reference also, I think, to the sort of culture that represents, and sort of their luxuries and the way God brings judgment on their luxuries. So a kind of interesting judgment on the notion of accumulation. In the Christian tradition, kind of following up and taking this up historically, we see that wealth is kind of somewhat ambiguous. It's not necessarily prohibited that there be private property, but the idea that wealth would be accumulated is often seen as potentially dangerous. And we can see this in a bunch of key figures, Lactantius, Augustine, Aquinas. And we eventually kind of get, and in my paper I kind of trace this a little bit through the tradition, where you move from kind of an early stage when it's very suspicious to a bit of a later stage in which there's a notion that, well, we're not necessarily suspicious of private property. We don't think it's part of sort of the state of original creation. We think it's probably necessary because of sin. And there's kind of prudential ways of thinking about how we might allocate property. And there's a very good discussion of that, of course, in Aquinas. All right, I have 2 minutes left. So my last piece here that I want to talk about is just this notion of from the margins and the idea of doing theology and thinking from location. And a lot of kind of Christian theology these days and biblical studies these days are emphasizing the way in which all of us approach the biblical text, approach our theological context and our culture from our location, right? We can't escape our location. We're embodied. We come from a certain place, and so we're always going to look at it. And so in what ways can we acknowledge our location, but also try and inhabit or look at these issues from the location of other people? And particularly, what might it mean for scholars like us at a conference like this one to think theologically from a location at the margins? Because to be honest, of course, we're not at the margins. We're in a very good place here, in a very beautiful place, and none of us are really, we may not be wealthy, but we're not lacking for much, right? So what might it mean to think from the margins? And further, kind of an adjunct to that, what might it mean for us to think Christianly about property as a component of a good society? And this quote from Augustine is sort of a theme that's often played off in kind of contemporary political theology about how we think of a society. What is the object of the love around which we're ordering a society? So just a few observations that I'll throw out that don't necessarily connect, but are just some thoughts. First of all, I think a society ordered around private property is an idolatrous society. Large systematic disparities in wealth from this kind of perspective really are unacceptable. Efficiency in consequentialist terms is a prudential concern. It's important, but it can't be a basic normative value. And last kind of piece in my last 30 seconds here, have we really listened to voices outside our circle? Have we listened to the immigrant? Have we listened to the migrant worker? Have we listened to the person who hasn't had adequate education and adequate opportunity to get a job? Have we listened to the person who's been displaced by environmental catastrophe or other things like that? And I would suggest that if we haven't begun to do this, then we haven't even really begun to engage in a properly Christian theological reflection on the question of what property law is and what property law ought to be. Right down to my last 3 seconds. Thanks.
Very proud.
Now we'll hear from Professor Helmholtz. It's your floor.
Thank you.
Professor.
This talk is quite a bit different, and it was suggested to me by Sir John Baker's comment on a series that John Whitty has started and is running on the relationship between law and the Christian religion. Sir John Baker mildly criticized this project, saying that most of the English common law, in most of the English common law, there was no place for religion. And therefore we ought to tone it down in this series. Well, that got my curiosity and riled me up a little bit, so I thought I'd try to find out what was the place of religion, if any, in the property law in England between the period in which John Baker knows the best, 1500 to 1700. So I decided to do some research into the case law, look at the cases and find out, did religion play any part in the English common law cases about land and other chattels during that period? And what I found was that in the property cases, there were a great many more references to the Christian religion than I had expected. It surprised me, and this paper is about what I found. And I found really 3 different categories. First, the use of Scripture to support arguments of lawyers. Second, the use of the religious law, mainly the law of the church, but also of new Protestant religious principles. And third, the invocation in the cases of Christian moral principles being applied to legal controversies. So I want to give you at least one example, maybe 1.5, of each of those 3 categories to give an indication of what the cases show. Now, my first example deals with the effects of the statute of uses from 1534 and 1535. Some of this might not be familiar to you, but it would have been familiar to any property lawyer in the 16th century. Now, the effects of the statute of uses on land titles in England were described and justified by the evocation of King Nebuchadnezzar's tree in the book of Daniel. Now, for those of you who are not as familiar with the Nebuchadnezzar's tree as I've become, I'll just quote a little bit of the book of Daniel. And it said that these were my visions. He's explaining the dream. These were the visions in my head while in my bed. I was looking, and behold, a tree in the midst of the earth, and its height was great. The tree grew and became strong. Its height reached to the heavens, and it could be seen to the ends of the earth. Its leaves were lovely, its fruit abundant, and it was food for all. The beasts of the field found shade under it. The birds of the heavens dwelt in its branches, and all flesh was fed from it. What does that have to do with the statute of uses? Well, it's not obvious, I think, but the question was what kind of new property law interests were made possible by the statute of uses. It was a very disputed topic, and the King Nebuchadnezzar's tree was read to give it as justification for allowing an expansive reading of the possibilities under the statute of uses. The tree, it was said in the English case law, in it were the fowls of the heaven built their nests, and under the tree-like statute a great part of the farmers and the lessees of the land, that is England, do lie for shelter and safety. In other words, the statute of uses possibilities were made possible by invocation of Nebuchadnezzar's tree, because it had sheltered so many different things, and so should the statute of uses. Now, if you think that's far-fetched, and it is a little bit far-fetched, you got to remember that it was a contentious issue at the time how far the statute of uses should be read to extend, and the tree of Nebuchadnezzar was used to give it an expansive reading. Now, I can see by some of your faces that you're not convinced by that, and it was only an argument that was proffered in the case law, but it is what happened. Second, that is the use of the law of the church. It used to be thought that the study and use of the canon law in England ceased during the reign of Henry VIII, but we now know that that conclusion is false. The powers of the privileges of the papacy were rejected, but the canon law itself was retained except when it was contrary to English statute and custom. And this mattered, of course, most prominently in the ecclesiastical courts, but it's surprising, I think, to find that it also mattered in the common law courts in cases involving real and personal property. It was relevant, that is, where the existence of a valid marriage could determine the outcome of a widow's suit for dower. And one operative rule was where there's no marriage, there's no dower. Determining that question required reference to the canon law, since the church's law defined what constituted a valid marriage, and that wasn't always a simple question. And there were many such questions raised in practice. To determine, for example, the scope of the statute regulating the validity of marriages between persons related by blood or marriage, a question came up in questions involving inheritance. It was necessary to know first what the canon law allowed, and second, what the effect of a Reformation statute had been. That statute limited the power to unions, which it allowed unions which the law of God itself had not declared unlawful. And this question involved both the knowledge of the pre-Reformation canon law and also an understanding of what the Bible held on the subject of unlawful unions. So it happened that the common lawyers and judges who had to look at that question when a case about inheritance came before them, and they had recourse both to the canonists, the medieval canonists, and to the theologians, though there was never a firm line dividing the two. The point is that the religious law was used to decide inheritance cases in the common law courts. The third example has to do with moral principles, or the third subject of my inquiry. I'm sorry. And it was used, that is, religious law was used to deal with technical questions within the law of real property. For example, a father's agreement to stand seized to the use of his children raised a valid use that was executed by the statute of uses, and that was effective. But a similar agreement with a stranger was not, And the reason given in the common law cases for that distinction was that nature, reason, and the law of God countenance and respects the love which is between the father and his issue, but not with strangers. Therefore, that had a impact on the question of what the effect of an agreement to stand to the trust of a particular person was. Similarly, a grant to a man and a woman in the heirs of their bodies that would ordinarily create an estate tail was invalid if the man and woman were married to other persons at the time of the grant. And that was because it would introduce dangerous innovations with inheritance. And I think I can prove that the same principle about application of a moral law had to do with the origins of the infamous rule against perpetuities. If you look at the early cases, the rule against perpetuities is not a device to protect the freedom of alienation of land titles, freedom of land titles. It's because the person who set up a perpetuities was fighting against God by attempting to project his own will too far into the future. And I think I can prove that that was the early cases about perpetuities had to do nothing about the land market, but rather with that principle that man should not act, in a case, should not act like God. So I think it would be a mistake to think of religion's influence in my circumstance as criticizing or resisting the law. My findings don't quite fit that title of this conference, which highlights religious critiques of the law. But at least in this field of inquiry, Christianity was most commonly used to support and to interpret existing law, not to undo it. Conscientious refusal to obey an unjust law, what we think of as the most common reason for invoking freedom of religion, did not appear in the English cases involving real and personal property. And that might seem disappointing to some of you, but it doesn't to me. What I can say to the contrary is that religion did play an overt role in the thinking of an average English lawyer between 1500 and 1700. What Thomas Shaffer wrote about the modern legal academy, that it, more than any other, has systematically discouraged and disapproved of invoking the religious tradition as important or interesting, finds no support whatsoever in the English case law of property between 1500 and 1700. In fact, the reverse is true. During those years, even within a seemingly secular field like the common law of property, the Christian religion always occupied a legitimate place. That is, property was mixed in with religion, and religion was mixed in with property. Thank you.
Now we've allotted 20 minutes for questions of our two distinguished panelists. Yes.
So this is for David. So one of the, it seems to be sort of central or interesting questions you've got when you read the Bible on economics and what it says about property and economic relationships, right, is that the Bible's written in a society in which there isn't economic growth, right? So the idea that you have that through commercial activity you can have sustained exponential economic growth, that's something new in human history that happens for the first time around 1900. And if you look at Munger-Madison statistics and other attempts to sort of do historical GDP statistics, it sort of goes that way. You don't have sustained economic growth. And so what I'm wondering is if we think that modern commercial and industrial societies are something new in human history, in their ability to produce sustained exponential growth, as opposed to a society, right, in which there isn't sustained growth, you go in many ways sort of zero-sum game, right? So you become wealthy in the New Testament by being a publican or a tax man or something, extracting wealth from others. Does that change how we should read those biblical texts? Is there something different about the modern economy morally and how we think about it? But there's certainly something different about it in terms of its productivity and the amount of wealth that it produces and the way in which it produces wealth.
I mean, I think my initial reaction, so I have two initial reactions. One is to question the question a little bit, and I think sort of as a historical statistical matter, it's pretty unassailable, but what is the assumption behind the establishment of Israel and its original sort of missional purpose? Would it really have been as static as you're sort of suggesting, or is part of the issue there that Israel and no other nation has ever really fully fulfilled that original purpose? So I would sort of question kind of whether that's the original assumption behind the text. But I would also suggest that I think the texts are useful to prophetically critique the assumption of what growth means, because you're throwing around ideas like GDP and things like that. And you're kind of invoking the Industrial Revolution. And of course, there's all sorts of goods that we benefit from because of that, but there are also all sorts of evils or externalities, if we want to use that phrase, right, that it also throws off. So doesn't a text like the one I put up in Revelation really, for us as Christian thinkers, really radically critique what we think growth means and what we think a good society actually means and what we ought to be structuring ourselves around? I think that's how I would respond to that.
I have more an observation than a question for David, but the observation goes along these lines. Well, it is a question, really. Have you had a chance to look at John Paul II's encyclical Contends?
Yes.
How would you integrate his encyclical into your analysis? Because I do think you part company at several points.
I mean, I may or may not, and the chapter that I was working on was getting long enough and ponderous enough already that I didn't have an opportunity to kind of go through the whole modern Catholic intellectual tradition. And I also am aware that there are sort of different ways of interpreting that encyclical.
Mm-hmm.
Maybe I would interpret it more through Pope Francis's lens.
Oh, I would. Absolutely. I think the effort to make a neoconservative article of economic dogma is misguided.
Yeah, I probably would agree with that. And again, it's not the sort of critique that I'm raising, similar to Aquinas, isn't to suggest that we should have no private property or that it doesn't provide goods in society. It's necessary for the prudential ordering of society. But it is a second order good. It is not part of the original good of creation. And I do think we have to recognize that to the extent we're drawing our theories of it out of ideas of scarcity, we're missing something, right? We're missing something about God's original design for creation.
Thank you very much for both the papers. I was going to ask a question of Dick Humboldt. The period 1500 to 1700 is, as you referenced, a period of reformation in part, but also continuity. And the one place where there's radical discontinuity is on the massive dissolution of church property during the Henrician Reform and Edwardian Reform. And the disappearance of that often into private hands.
Mm-hmm.
I'm wondering if there was a theological justification that begins to emerge in support of that, and whether some of that percolates into the legal treatises and cases that you've been dealing with in that period. Because it's a major, major shift in land ownership.
Well, I've in fact got one case on the subject. Could I just describe it for you briefly? They had a medieval gift, which in part was for the saying of masses, and that became illegal. But the case came up before the court, what was going to happen to the land, which was the source of that, and it was saved by the inclusion of it in a provision for the poor. That was a part of the use of the property, and the whole thing was saved because it contained that, and they invoked the principle that he who robs poor men of their living is a greater thief by the law of God. That was a justification given in the case for making the inclusion of both of them. So it did come up a little bit, but I'd never seen a case which questioned the legality of the statutes under which the dissolution of the monasteries was accomplished. So yes and no, I guess, is my answer.
Yes.
Also, I guess, for a really interesting presentation. Sometimes when the question arises whether religion influenced whatever, the law of some purity or culture or whatever, and
would say that that's true of every justification given by judges. You can't prove that anything caused anything else. What you can show is that the religious thought and religious language was so much a part of the life of these lawyers that they couched their arguments in terms of what the Bible said or what the religious law said. And to say that that it was influential or not is, of course, problematic. But so much is problematic in deciding whether it was the judge's what he had for breakfast or something else, that at least I think it's worth saying that even in a rather unexpected area of English law, which is regarded as a technical area, and it was a technical area, in which religion shouldn't play any role, you do see it over and over again invoked in the cases. And that's about all I'm saying, but I can't prove that anything caused anything else. And I don't think you can do that even if you're an economist. That's my...
Dick, did you notice any significant change over time in the cases that you were looking at? I mean, an awful lot of things took place during this era. I don't know if you looked at other cases, but Civil War era. Was there any shift in the use of religious language?
That's a good question. I just don't know the answer. I didn't... There are a lot of cases. I got tired.
Criticisms often made of natural law theory that it's great in theory, in practice, natural law just gets evoked to support the property interests and the wealthy. I'm wondering whether in either of your exploration you saw that scripture was used in the same way to just support the property interests, or does it ever get used by courts or others in a more prophetic sense that we the sort that David Opperbeck was just talking about, that we try and aid the poor, the widow, the orphan, etc.
Well, unless you count the case which I just cited, where they changed the bequest for masses to one for the poor, or they didn't change it, they interpreted it that way as prophetic. But I wouldn't myself. No, I think it was they wanted to fulfill the moral purpose of the testator. It's like the Cypre doctrine, fulfill the obviously moral, charitable bequest, and here was one way to do it by citing the law found in the Bible. But no, I don't think I found much.
I mean, my observation on that would be just more broadly historical, but I think, from the early era of the early apostolic fathers, there's a pretty broad criticism of private property, and some of them even suggest that a faithful Christian ought to divest himself of property. In fact, there was a trend of wealthy Christians divesting themselves of all their property, although for some of them it was sort of a very lengthy process. Lactantius, for me, is a really interesting figure because he's kind of a transitional figure between that early apostolic era and sort of the Constantinian era. And so he has a little more room, I think, for the value of private property. And then by the time you get to Augustine, you have Augustine sort of invoking private property against the Donatists, which is a really interesting use of it. And then by the time you get to Aquinas, you have sort of a more robust Christendom, and a more robust defense of the prudential uses of property law. So I'm not sure what that observation shows, but it does show that contextually, as the church occupies different places in society, it views property law differently.
Just follow up on that a little bit. You said against private property, and it seems to me that clearly property in some level is supported in the scripture, like Israel. It's really good that it has property, and sometimes you spoke about communal property as being better than individual property, but individual property isn't anti-private in the sense that the public-private axis is different than the the individual communal aspect. And when the people were giving their money to the church, they were giving it to the state. It was still private property. It was property they were holding commonly. And I'm attacking what you're saying. I think there's clearly a critique of forms of property ownership, but instead of private public, it seems to me like what you've made a case for is it was private communal, that Israel had property in clans, not as individuals. Is instead of private public, would we be better off talking about individual versus commons? But it's all private, but it's not individual, it's commons.
Yeah, that's a good, I mean, I'll accept that critique. I didn't mean to imply versus private versus, say, government owned or public owned, right? But and in fact, I think in many of the early Christian commentators, this was part of the wrestling that they did, because they recognized that, you know, to divest yourself of property or to have to be able to support the poor, you have to have something to support them with. And so that's partly how they justified at least the prudential fact that some Christians could have property, because otherwise nobody would be able to support the poor and everyone would just be poor. Right.
Somebody's got that.
Yeah, no, I think it's a very good point.
Dick, I'm just wondering, you happen to count, you mentioned the endurance of canon law even amid and after the recent Reformation, and in Scarisburg's biography of Henry VIII, he talks about this and why the Act of Supremacy was amended to not give the king control of canon law. I mean, Scarisburg doesn't really have an explanation for it. He struggles to come up with why something that would appear to be inconsistent with royal supremacy, such as canon law and its endurance in law, would have been allowed to go on. I just wonder if you can help resolve that problem.
Well, there was a statute which dictated the result and said that all the canon law would remain in force except those aspects of it which were contrary to the traditions of the common law inherited from the Middle Ages and were contrary to the royal prerogative. But the way that was interpreted, and the way that was interpreted, was to preserve the canon law except for those two exceptions. And most of law is not really about the power of the ruler. Most of the canon law is about the details of organizing our society and relationship between people. And that's what was preserved, and that's really what was most important about the law. In the property law and in the ecclesiastical courts, which were continued.
Question for David after that. So I was struck by your description of early Christian tradition of property as not being in moral law or natural law, but justifiable by positive law. Because in the 18th century, Lord Mansfield described slavery almost the exact same way, that it could not be justified by moral or natural law. And so, on one hand, that might lead us to be very nervous about our account of positivistic property law today, that we could justify slavery that way. What are we forgetting about now? On the other hand, it suggests that critique of property law might be too broad. If it's the same critique level against slavery and against my ownership of an iPhone, then maybe there's a... So I was wondering if the early Christian critique had whether sort of tiered attacks on specific kinds of property as being especially concerning, or if it's sort of against all individuals' property at the same time.
I don't know that there's any kind of tiered attack, and then I think for most of the history of the early church, the possibility of slavery was assumed, and it may have been different kinds of slaveries in different contexts. But unfortunately, there was a tradition that some people could own the labor, and not just the labor, but the other people could own slaves, and that, in fact, was possibly part of what God had ordained, and possibly was sort of prudentially useful in those circumstances. But that does get, I think, to two things. I mean, one is, if property is a second order thing, then we can always critique specific applications of it. It's never absolute. And secondly, it gets back to something I didn't really talk much about, but others have talked about, which is this idea of the imago Dei and the notion of the human person. So what is a human person in relation to the ownership of property, right? The value of a human life takes a lot more value. I think even in the Hebrew scriptures, though it allows for slavery, there are various provisions about manumission of slaves and so on that at least reflect that a little bit in its own context.
I have a question for David also. You know, if we grant that property is not or should not be an idol, from all that you've read there, what positive changes would you conceive or support with respect to property regime as it exists in the West today?
Oh goodness, you're gonna ask me for details?
Take your time.
Well, even bring it, you know, not from, you don't have to bring it to the ground, but somewhere in between.
Well, so I'll try to answer just from the context I'm most familiar with the details of, which is intellectual property. And this, you know, presents even more difficult kind of theoretical issues with respect to property ownership and its prudential ownership. And I've sort of done a lot of work on patents in pharmaceuticals and access to pharmaceuticals in developing countries and so on. And you know, unlike a lot of my colleagues in the IP Academy, I'm not sort of totally anti-IP, which ironically many are. But I do think there needs to be limits on that. So that's a way I could say, let's look at this, and is it really wise and just and good and loving that our primary way of financing applied drug discovery is through patents, which are essentially funded through the stock markets, right? Because they're publicly traded companies. I would suggest probably not. I don't think it's even that efficient, actually. But maybe that's one place where just that I know a little bit about that I might poke at it a little bit.
So, but do you think we should, for example, North Carolina has abolished the rule against perpetuities, at least with respect to trusts. Should we bring it back?
Beyond my expertise, I don't know.
All right.
I have an answer to the perpetuities.
Okay, well then, thank you.
Well, I think we're ready to go on to the second half of the program, which is going to focus on the role of religion and contract law. And for this, we have Joel Nichols, a former colleague of mine and a person that we were unhappy to see leave Pepperdine almost 10 years ago now. And we also have Scott Pryor from Campbell, who's an expert in commercial and bankruptcy law. And we're all looking forward to their discussions about the role of religion with contract law.
Good afternoon. It's good to see all of you. I appreciate you staying awake. We'll see if I can continue that for 10 minutes. It's a high aspiration. I have just a few minutes here, of course, to talk about contract law, and the title, as is in your program, is about consent and Christianity and conscience. I'm going to spend a little more time on this idea of consent as a theme, less than I'd like in my time today on Christianity and the themes, some of the ones as David pulled out. Maybe we'll have more time for that in our questions. Let's begin this way. I mean, remember back, for those of you who are not contract law scholars, you try to put it out of your head. At the core here, we're thinking that contract law means that we're bound by certain kinds of promises. And it's specifically limited to what things are legally enforceable. And we do that because we've consented to certain outcomes. They're within appropriate boundaries. I could consent to some things that the law won't enforce, right? If I have a hitman take out David Drunin and the hitman doesn't follow through, I'm not going to be able to sue him and have the courts enforce that, even though there might have been consent on that. We also don't consent to other kinds of things, but we might have other enforcement regimes. If a high school guy stands up his prom date, there will be repercussions, but it's not legally enforceable. So we're talking about a different kind of enforcement regime. And specifically, we want to think about the idea, what role does consent itself, if you will, free will perhaps, in the Christian context, have at all? Is it relegated almost to a term of art, if you will, and not the way we usually use it, but something much more like consideration in contract doctrine, which we say has all this traction, but if a first-year student tells you it means to consider and think about something, that's the wrong answer. So when we start through this, I want to think about the idea, too, that there need to be places that we do change our mind. Of course, it's not the case that every promise we make, every statement we make means that I should always be held to that with the firmest consequences. It might be trivial. If I go to dentist A and I've committed I'm going to go back and make an appointment with dentist A, and I decide to change my mind and go over to dentist B. That's not a big deal, you say. Depends on the level of the promise, but again, we do things like this. It might be a larger scale thing. I've committed to a series of car payments, but because I have a series of doctor bills, I've decided that I can't continue my car payments. That's a very morally defensible thing for me to do. I have to figure out the way to not make the payment, to return the car, kind of lawyer things to figure out, but we wouldn't at the immediate outset say, Nichols is a bad person because he made a promise to make car payments and now he's not doing it. Right? So we always have these outs. And at the basis of kind of any of our enforcement regimes is this idea that we have agreed to certain things. And I think in part that means we've agreed to outcomes. One question in contract law as it has evolved is, am I agreeing to the contract overall, if you will, or am I also consenting to the individual provisions therein? Right? The law wants to think and says that I'm consenting to every piece therein. I just think that's false, right, as we walk through that. So it looks more like a term of art. So just a couple of questions, which I'm not going to answer at all, about theological questions that might frame a bit of this. What role do we think about this idea of freedom or liberty? Maybe in terms that John Whitty was thinking about of Luther's kind of robust ideas of freedom, or maybe something else, but do we retain freedom not just to make promises, but to break them? What would that look like? What might grounding theologically look like for that? When we see contracts in the Bible, as David gave us more examples of property, we often think about the word covenant as having a stronger hold. We have a legal terminology of covenants. Interestingly, they're embedded within the larger contract. But does that kind of inform anything that we do? And this idea of conscience, how should we think about our own conscience with really mundane matters, like which house do I buy? Whether I pay money to the plumber who did a bad job fixing my sink. Now, I'll be really fair, right? You might say the immediate response is those things in the strands of longer theological tradition fall into the realm of pragmatic decision making. Those are not kind of freedom type decisions. Conscious is not the right word to use for this, Joel. Okay, so I'm guarded about the terminology, but we've got to have a hook for something. There is a moral pull that I feel that things aren't right. This plumber has come over at the wrong time of day. He didn't call me. He didn't fix the problem. Now I have to miss work again for a new plumber, but I also feel a little bit internally guilty, right? He's got to earn a living. He might not have meant to do a bad job. He might have other things going on. I'm making some conscience decisions, even at that core level, whatever the law tells me one way or the other. Now, a quick tour of some contracts things, just kind of historically. If you teach first-year contracts, you're talking about mutual assent, offer, acceptance, consideration. Consideration's this weird thing. It really means offer and acceptance. Let's not confuse anybody. But, right, we talk about this, and we act as if every contract has dickering back and forth. I will sell you my house for $100,000. Okay, then you return, I'll buy your house for $80,000. We go back and forth. It's a traditional contract model. That already doesn't work well in large-scale transactions. It's not very efficient, but that's kind of the underpinning, and we act like that informs all that we do. That's a theoretical basis. You move along to the 20th century, you quickly see the rise of standard form contracts. And this bumps somewhat into these individualized consent ideas. We still theorize that it works. It doesn't work really well. We just pretend it does. Now, standard form contracts are far more efficient. We don't really want to bargain about every single item. We want to reduce transaction costs, but they do favor repeat players. So imagine the doctor's office with your billing arrangement. You're one customer. They have dozens, hundreds of customers. It doesn't mean they can't change a bad term, and I've been known to bargain with an orthodontist office or the like, and they changed it. But that just means now it's better for me and worse for the rest of you, and you can't bargain next time, perhaps. Or more egregiously, take your cell phone contract. If I don't like, let's say, the arbitration clause or the choice of forum clause in my T-Mobile contract, I don't have to do it. I don't have to consent. Okay, but I like my cell phone. I need to do some things, so I'll go get one with Sprint. They have the same term. So does Verizon. So does AT&T. So do the small play. Am I really consenting at any point along the way? Or am I just playing the game because that's what we do, and I'm reliant on government or something else to help me out? Now, it might be, maybe Scott will help me here, that you can get me out of this on unconscionability or some kind of other exit strategy doctrine, but maybe not for the kind of non-egregious examples I mentioned. I'll go quickly through just a couple of other pieces without much sufficient depth, but this looks different as well in the electronic contracting arena. Kind of the turn of 2000, we struggled a lot with, can we use our terminology? Will it work with click wrap and browse wrap and the like? We've kind of conceded that it does. And it matters a little bit, right? If you're surfing the web instead of listening to me, you clicked through Pepperdine's I agree thing, and you even use traditional consideration. You agree to use it for appropriate uses, and you're not going to go do something else. You have choices. You could tether it to your phone instead of using Pepperdine's internet access point. You could listen to a boring presentation or two instead of doing your shopping for the day. So maybe it works okay there. It's a little weirder to think about consent in all the terms of service anytime you visit a website, right? But there they are at the bottom or up in the top corner. If you browse, you're consenting to all kinds of things. They're collecting all kinds of privacy data about you. Do we still think that there's some meaningful ideas to this notion of consent there? We could stretch this even farther if we're looking forward to next generation technologies. All the hubbub right now is about blockchain technology, which is effectively version 1.0 is the equivalent of Bitcoin and the way it's set up. Version 2.0, even within the last week, was a New York Times feature story. And that story, for example, talks about IBM and Walmart and other players developing these technologies for interesting things about how you track certain transactions all the way back. For Walmart, it's helpful that they have a salmonella outbreak because of their peanut butter. They can track back the source of the vendor because blockchain goes through a series of steps, each one authenticated by external nodes, not government players, and it builds upon it in interesting ways. But again, the idea of consent starts to vanish in some of these arrangements. Take one example of this. Let's say I have a computer that I've designed, and I've told this massive computer that I have, you do these computing technologies. When you have excess capacity, you can lease out your capacity to other computers that need to wire into you and tap out your capacity. You, computer, can make that decision. I'd like the royalties from it. My computer makes the decisions on its own. Does contract law and consent really have something to say about that? Or have we gone so far afield that we almost are using kind of different terminology or words that don't matter in the same sense? So again, my apologies for not tethering this itself enough to the theological basis for that, but hopefully we'll have time to play that out some more in our discussion and after Scott. Thank you.
Well, I'd like to begin with the typical but heartfelt thanks to Bob and the others who organized this conference. It has been a great reward and blessing to me, and I'm very thankful for being able to have this part. Well, what do you think of, in the American context anyway, what do you think of when you think of the 1930s? Perhaps the aftermath of the Black Friday, the stock market crash in 1929, the increasing effects of the Depression, the election of FDR, happy days are here again or not, breadlines, et cetera, et cetera. That may be what you think of, but I think of the nadir of the doctrine of unconscionability as a contract law defense. Unconscionability had always had a rather spotty history in the common law. It's been there since the 16th century. It popped up on occasion, most often, in courts of equity, refusing to enforce penalty clauses. Occasionally, in the law courts, there perhaps we could recharacterize many of the law court's decisions holding a contract unconscionable in terms of perhaps undue influence, which was not yet recognized as an independent contract law defense. Come over to the American side, and yeah, there are cases in American jurisprudence which recognize the doctrine of unconscionability. Again, lean toward most cases undue influence, perhaps reformation of contract would be a better way to look at them. But there were always a very few residuum of unconscionability cases that had something to do simply with or focused principally upon an egregious price paid for a particular good. Well, that's where things were, kind of a spotty history, but by the fourth decade of the 20th century, even that spotty history had largely, not completely, but largely evaporated, because after all, we don't see a doctrine of unconscionability in the Uniform Sales Act of 1906. It didn't even make it into the Restatement of Contracts, the restatement, we think now, Restatement First of Contracts in 1932. So it clearly was not hot on the topics of contract law defenses. Well, if that's where things were by the 1930s, where had they been, oh, I don't know, say 600 years earlier? Where did this doctrine come from? And it has its ultimate origins in terms of the medieval tradition, looking back on the Code of Justinian, the Codex, which had a provision that you could rescind a contract for the sale of real estate. The purchase price was less than 1/2 of the value of the land. That was sort of a freestanding, peculiar provision. It had not come into the law, Roman law, long before the codification under Justinian. I think it was either Diocletian or Maximus gave a royal or imperial rescript to that effect. So it wasn't really a significant part of Roman law anyway. But by the time we get to early medieval, and certainly on in that period of time, it had been rationalized by everybody, without going into the detail, in terms of the Aristotelian virtue of commutative justice. Fairness in exchange was the conceptual framework around which something like the doctrine of unconscionability was framed in medieval, late medieval, and early modern times. For the history of this, well, there's several people in this room that can tell you it from memory, and I don't want to intrude on or suggest I know as much as either Professors Gordley or Helmholtz about the history of it. There's someone else's history I found recently of great significance. Wim de Kock teaches at the Catholic University in Louvain. His doctoral dissertation of 600 and some pages dealing with the development, moral aspect of the jus commune over the couple hundred-year period is an extraordinary work, and I commend it to everyone's attention. So anyway, there was this well-thought-out, seriously rationalized doctrine of fairness in exchange, which is tethered to Aristotelian virtues, that was active and vital. Well, maybe that's overstating. It was certainly active in medieval, late medieval, and early modern times, and it continued even thereafter, if not so much showing up in the common law of either England or America, but it was still there in the background. So if you look at the theological writers, and particularly theological writers in the Protestant tradition, which I find myself, if you look back to the middle of the 17th century, there was the meeting in Westminster to try to come up with the statement of doctrinal beliefs for the reforming English church, the Westminster Standards, most detailed of which was the Westminster Larger Catechism, which is extraordinary work. Its analysis of the eighth commandment, thou shalt not steal, included very specifically references and prohibitions of injustice in contracts between men. Well, it didn't further define injustice, but if you look at other writers around that time, clearly they had in mind the same thing that everybody else had had in mind for the preceding 300 or 400 years, rough equality in exchange. And that continued even thereafter in theological writings, certainly up to and including the early and middle of the 19th century. The famous Presbyterian theologian Charles Hodge made the very same points in his systematic theology. So this was in the background, both legally, deep background legally, but certainly more foregrounded in theological understandings that were, commonly held throughout the England and America well into the 19th century. So it just gradually faded away. It was never heavily used, and it just seemed to have pretty well disappeared in light of the rise of the will theory of contracts. We are bound by contract not because it is a form of exchange that conforms to the virtue of commutative justice, but because we simply will or choose or consent to enter into a contract. So by the 1930s, it was in a deep, deep backwater. Well, what happened in, let's say, the 1940s? And we have Carl Llewellyn taking his first stab at drafting what now we know as the Article 2 of the Uniform Commercial Code, and he proposed a revitalized doctrine of unconscionability. He started that in 1942, various editions, edits, changes. 1949, the committee notes to the drafting process had something that looked very much like commutative justice as the framework within which courts would analyze unconscionability. Well, that didn't survive the cutting room floor. By 1952, that was gone, and we have what everybody has read if you took sales law anyway, Article 2-302, which says that a court can find that either a term or an entire contract is unconscionable, with no further definition in the statute. Go back and look at Article 1, where you have a plethora of definitions, no definition. Look in the 2-100s, no definition. You look at the comments to 2-302, and there is a bit of a circular definition. That is, a contract is unconscionable when, well, it's unconscionable. And there are some citations to a few cases which really aren't very helpful. So we are left with an undefined term. But it's there. And that represented a significant change from what had been the declining history of unconscionability. So what happens then? Well, we have Judge J. Skelly Wright and Williams versus Walker Thomas Furniture applying the Uniform Commercial Code version of unconscionability, or at least his interpretation of it, to a case that wasn't even subject to Article 2 because the facts in the case took place before the district had adopted Article 2 of the Uniform Commercial Code. But Judge Skelly Wright said, well, it just restates the common law anyway. Well, maybe, but in any event, that's what he said. And we have the doctrine of procedural unconscionability and substantive unconscionability, and they are only slightly better analytical tools than unconscionability standing alone, and I mean slightly better. So what happens after that? Well, we continue to have a development for maybe the next 20 years of applying the doctrine of unconscionability without any tether to much of anything at all. It is, to a large extent, an application of the doctrine of that the equity is the length of the chancellor's foot. If you have a provision in a contract like cross-collateralization of consumer products, Williams versus Walker Thomas Furniture, well, that just seems maybe too much, or at least remanded for trial. Other cases, arbitration clauses in employment contracts. California has a beef with those, so often they were declared unconscionable. Arizona and New Jersey had a big thing with unconscionability, and they applied it. And in most cases, it was nothing more than a conclusion reached by a court with respect to a term which the court thought was somehow opprobrious or just not worthy of judicial enforcement. So, well, what do I say? What do I say? I think we should just go back to the idea, at least, of commutative justice. Fairness in exchange, representing the standard by which we're going to evaluate substantive unconscionability when it comes to a contract. The challenge I've set before myself, and maybe somebody here can tell me, is how do we do that in a modern market economy where we have products that are differentiated in multiple but insignificant ways, and products where the difference in terms can often be found in non-salient provisions, such as giving up the right to consequential damages, disclaimers of warranties, and the like. How do we measure fairness in exchange when the object for which we are exchanging our money or our promise is so far different from the historical understanding of simply a sale of a horse or another good, which the judge, or at least with a little bit of evidence, would be able to evaluate? My short answer is, I don't know, so I'll put the burden of proof with respect to conscionability on the seller when it comes to a case dealing with a standard form contract or electronic contracts. The seller, if challenged on a term that is in a contract that differs from the baseline of remedies provided in Article 2, would have to overcome a presumption of unconscionability, unfairness in exchange. And if we go forward with that, perhaps nothing would be found unconscionable, perhaps many things would be, but in any event, I think the market would quickly adapt and correct for those problems.
Yes, sir.
This is for Scott. So when I think of Aristotle and with justice and with thought, you talk about goods of exchange of goods of equal value. But then when you get to books 8 and 9 on friendship, the end of book 8, the end of book 9, when he talks about reciprocity between friends, he says the recipient accepts the value of exchange. And as I understand it, that finds its way through the school of Salamanca, eventually Karl Menger, and our subjective value, subjective in terms of the recipient?
Market price. That is, and this was the leading tradition through medieval and early modern times, is that if you paid the market price or within some significant range of the market price, that's good enough. There was no metaphysical objective value. The objective value is the objective valuation of the marketplace as a whole against which you would compare a particular transaction.
Gentleman in the back? Yeah.
Mr. Breyer, I have a question for you. It seems in the scriptural tradition, we have another idea of vow that's very different than the idea of exchange. And it's not based on equivalences of what's been given. If I vow something to God, I'm not giving something back to the sacrifice that's equal to the grace that he's given me. It's unequal. And when God does things, to me, I have this problem. But why isn't that as much a good ground for cultivating the virtue of the people as equality of exchange? I guess the virtue it is, it's against weakness of the will. When I decide to do something, I'm going to carry out what I've decided to do. And if we're looking for a scriptural hook, we have this idea of the vow and its sanctity. Why do you prefer this Greek pagan notion to our good solid notions of vowing as a basis of conduct?
Well, a couple of things there. Vows, I tell my students, essentially are offers of a unilateral contract. I promise God that I will give him such and such if he does such and such for me. If he doesn't, I don't owe him the money. I don't owe him the sheep. I don't owe him my son, as Hannah devoted Samuel to God's service. So in any event, we have a situation there where we make an offer with a valuation that we have chosen. Not God didn't set it for us. We have chosen to offer him a sheep or a goat, cattle, or the like in return for what he gives to us. I don't know how else we would begin to value the relation, value the transaction apart from the will of the one who makes the vow. I don't know, because obviously God is a party only in the sense that he causes providentially to occur what we have asked for. Secondly, the vow was clearly, I'll take the position, that it was clearly part of the system of life for the people of Israel and the land of Israel at a particular time, and I draw little direct connection, there's not nothing, but a little direct connection to the world of commercial transactions, evidenced by my click on the I accept for the terms of service at Pepperdine. And I didn't begin to go into it, I have a whole bunch of biblical word study analysis too that would bore everybody. Yes.
I have a question for Joel Nichols, and the question is this: perhaps the starting point with consent is misconceived. Perhaps what is called for is a theological reflection, not on consent, which you point out correctly, I think, is a legal fiction in many of these cases, but rather a theological reflection on economic power and the relationship of the individual to vast economic power. And that may be a more productive starting point. How do we relate to Microsoft, let's say, or some other large force out there that controls the marketplace?
Right. I think that's a really apt observation, and it actually ties in with what Scott's talking about as well. Because you need to find, like, what exit provisions do I have, especially in consumer versus business, consumer versus government, whatever contracts, when I have so little bargaining power, and we're going to let me exit based on the basis of unconscionability. How much do I have to know? If you put more lines in a contract, does it really mean that I understand what's going on? Or instead, are we going to step in other ways collectively via a court system, unconscionability, or some other escape valve, or via a consumer protection board at the state level, federal level, city level, whatever that looks like? I'm saying we're going to police players because of this inequity. So of course we see that kind of external regulatory area stepping in to the contract realm. But for lots of reasons, we don't want it to step in every transaction, even to consumer transactions. And so we are left with figuring out what work is there to be done for the doctrine itself, within the doctrine itself, of consent, unconscionability, or other doctrines, kind of aside from external forces coming in to this realm.
Let's suppose that Professor Pryor is right about two propositions. One is there's a substantively unfair price. Something fair price, unfair price. He identifies it quite correctly as far as the historical traditions concerned with the market price. There's just questions. What's fair about that? Let's suppose for a minute that's true. Let's suppose that there are terms that are substantively fair and terms that are substantively unfair. Professor Pryor equated the fair terms with the terms the law would read in under the UCC argument 2 if the parties agreed to anything else. Now again, what makes them fair, what makes them unfair, we could talk about a long time about that. But let's suppose it's true. If that's true, there's such a thing as a fair contract. Fair terms, fair price, fair auxiliary terms, or terms that will be read in. If that's true, doesn't that solve a great number of the problems that you raised? Because, Professor Nichols, because when you're talking about consent, you're talking the language of 19th century will theory. And you define contract in terms of the will alone, and it becomes very mysterious that I'm bound by all sorts of things I never thought of. And sometimes I can think of something like the price, and I'm not bound because it's unfair. If you think of it in terms of what I'm consenting to is to buy some object, which I do know what it is, on fair terms, then we can see why it is that if the term becomes unfair, the price becomes unfair, there's relief given. And if the terms deviate too much from the ones the law would read in, the terms are unfair and relief is given. But at that point, you have to think that the contract has to have two elements. One is voluntariness, the other is fair exchange, which is what I'm consenting to. You can't think of it the way the 19th century did, as though the obligations are made up out of my own head. You have to think that if I'm going to exchange, on fair terms, there's a great deal to be said about that I don't know. But I do want to be treated fairly. Wouldn't that solve your problem, as you suggested, Mark?
Well, it solves some of the problems. It gets right back to what Dr. Reed is talking about, though, which is when there are as many economic disparities and lack of knowledge in terms in the marketplace as there are between major players and consumers that will continue to evolve. Aspirationally, theoretically, I like that move. I know that pragmatically that works well. I mean, one of the turns to Professor Pryor I would ask is that, and maybe you can chime in on this because you know this better, I think, than I do, is that the doctrine of unconscionability, while it gets played out in a few cases, they tend to be a one-way arbitration clause here or there, but otherwise we're not seeing that doctrine do much work independently. And so whatever terms are there that aren't overruled effectively by governmental regulation tend to be the governing terms.
Yeah, it's the problem of the lemons in economic analysis. That is, when you have a variety of terms, large number of terms, it makes sense for typically the seller to put in the non-salient terms provisions that are particularly advantageous to the seller. Those almost always will be with respect to contingencies which are unlikely to occur. Thus, for most people, they rationally don't care because it's not going to come up very often. But if it happens to be you whose cell phone blows up and does actually bodily injury to you, well, you care, but you find out that you've contracted it away. Well, you can contract. I don't have any objection to contracting away your right to recover for damages caused by a breach of warranty. I don't care that even that you sold goods as is, as long as the as long as the total price accounts for the risk, small risk, perhaps great liability, but as long as the price accounts for that, that is commutative justice, and we don't have to evaluate things on a case-by-case basis. We want to look at them after the fact in terms of, though, the original price, because a lot of the unconscionability cases always look at things that, as economists complain, and rightfully so, post-deal. Well, the fact that something works out for me bad after the fact is a cause for regret, not for setting aside the contract. So we have to price things up front, taking into account the risks that have been contracted away, risk with respect to unlikely events tucked away in non-salient contract terms.
Can I chime in again? I want to agree with you.
Well, yes, absolutely.
You're absolutely right. And that same point was made by Guido Molina in the early 17th century and by John Dumas, that a waiver of warranty of the contract for sale would be a fair thing to do, provided you adjusted the price to allow for the fact that the risk is shifted. Now, if we read the law in economics people, which we should with great attention, we will discover that what parties would do if they knew the whole story is put risks on the person that can bear them best, most easily, at the lowest cost.
Sure.
And then they'll adjust the price to reflect that division of risks. What should we do if we read a contract in which a risk is placed on a party for the reasons Professor Nicholas has given? That party's unlikely to know it's even there. But we can see that the party on whom that risk is placed is not the party best able to bear the risk. What our economics should tell us is the price hasn't been discounted to compensate for bearing that risk, because the guy who put it on him would bear it himself if he had to pay the full price, giving the full discount. Therefore, the contract's unfair in exactly the sense you said. And so how can we go through terms and see if they're unconscionable? We can see it by asking ourselves, look at this shift of a risk from its normal position. Which party could best afford that risk? If we see it shifted on the party who could bear it worst, we know it wasn't compensated.
So I love both of these presentations and contract law stuff. I enjoy both of them. So, Professor Pryor, your proposal fills me with horror for a variety of reasons.
Well, thank you.
Well, one sort of basic question I have about community justice. I understand the idea of fairness in exchange, and what fairness in exchange means is the market price. And historically, the places in which we would find there wasn't fairness of exchange would be in situations in which there might be monopoly power for some reason, or sort of other reasons there might be contractions of supply or something like that. So one of the effects, it seems to me, of saying that we're not going to enforce a contract in which there isn't fairness in exchange, right? So the contract price deviates significantly from the price of the competitive market, is that that will create a disincentive for arbitrage, right? Because normally what happens is the availability of rents means that I'll find the good in the market where the price is low, I'll bring it to the market where the price is high, and I'll sell it. And it seems to me is that we want arbitrage to happen.
Yes.
Right, because arbitrage is what's going to overcome gets us back to the competitive market price. So it seems to me as if we take this seriously of wanting to have exchanges happen at the market price, which we think is the fair price, we create a perverse incentive if we refuse to enforce contracts where there's possibilities for arbitrage, and the effect of that actually is going to keep the available price well above the market price. And so given that, right, it's one of the reasons the theory, even if it's sort of normatively elegant, strikes me as potentially pragmatically quite pernicious.
Yeah, yes, and the problem is, I think what we're doing, what your question raises is what is the relevant market? And that's an empirical question. So Williams versus Walker Thomas Furniture. Mrs. Williams had no means of transportation. She was African American. She lived in Northeast DC. She couldn't go out to Virginia and do a whole lot of shopping for stuff. Just wouldn't have happened, wouldn't have worked. She couldn't have moved the stereo from a store outside the district to where she lived. She had a relatively narrow market within which she could shop for her stereo or her Divino or everything that she was buying. So it made sense and thus I don't know that particular transaction, her case, was unconscionable. I mean, she had a relatively small market. There was no way around that small market for her at that time. Today, of course, the relevant market would be much larger, but you have to take that into account. So I want to incentivize Walker Thomas Furniture to buy stuff wherever, it got its stuff, and sell it for the market price of the market in which it operates. And as long as that market price took into account the fact they had this dragnet clause with respect to repossession, I'm fine. I'm not certain, I have no conclusion in advance as to whether there would be more transactions found unconscionable in my approach. I just think it fills in the unknown variable of substantive unconscionability with something more substantive.
But I still don't understand. So imagine the case, right, in which I know, right, that this price is above what the competitive market price would be, right, because, there's been a flood, and so there's a temporary constriction of supply. So in that case, if people contract at above the market price, are we going to say that's substantively unconscionable? Because, so what I'm asking you to do, right, is consider the hypothetical in which we take the epistemic objection off the table. We just know that this is above the market price. So, but we also know, right, that if we enforce these contracts, there's the possibility of arbitrage, right? So do we enforce the contract or not in that case?
Well, market, again, you have to define your market both geographically and temporally. What is the market price at that point in time when there happens to be an artificial constriction on supply? Well, the market price will be higher.
But historically, as I understand it, the way that was precisely the case in which the casuists and the jurists would say there's not, and Professor Corley's going to tell me I'm wrong.
He's going to tell you what the right answer on that is, historically.
That you don't have to meet the judge.
Yeah, yes, and I will defer to my better.
I think you made a mistake.
Okay,
Thomas
probably.
Almost certainly.
No.
Okay. People discuss this case a lot back when this was law. What happens if I buy where things are cheap? They move prices go up and down according to quantity available. If I buy where it's cheap and I sell where it's expensive, is anything the matter with that? The answer is no, for the same reason you just gave. I bought on a market where it's cheap, I'm selling on a market where it's expensive. Now, the extreme case put by Thomas Aquinas was this, and he took it from Cicero. There's a famine in Rhodes, and there's no grain, and the price has skyrocketed in Rhodes, and nobody's done any rationing or the things the government might do. The price is just going through the ceiling. So somebody hires a galley, loads it with grain, and a bunch of stout rowers, and he rows to Grove, rows to Rhodes. And he passes a whole bunch of grain ships on the way. These guys just row a lot faster. And he arrives at Rhodes. Now the question is, can he sell at the famine level price? And the answer is yes. That's taken for granted by Aquinas, the Christian saint.
Yeah.
Cicero said that.
No, Cicero said the opposite.
Cicero said the opposite. Now does he have to tell everybody else, hey, there are a whole lot of other grain ships on the way? Cicero says yes. Aquinas said no. And given the way Professor Pryor has defined the just price as the price on a given market, Aquinas is exactly right. If you would like that result, think of what the government should have done with the famine in terms of rationing.
Yeah, and in fact, I give that case. I make them read, Cicero de Officiis in English, of course, his case and Aquinas, and it's fascinating to see the students wrestle with this, but come to the conclusion that the doctor of angels says so. That's the way things go.
Can you try it out on the price of life-saving drugs? Just to give me a context of this, right?
Well, I think that's David, that's a patent question. Well, let's ask it.
In on it too, but the notion that the price, Charlie buys a drug, and the R&D costs are already taken care of, and he jacks it up, 300 times, and it's life-saving for those folks. Is that an unconscionable contract, or is there a market problem there?
Yeah, well, there's a market problem there because there have been so many distortions of the market up to that point that I don't know how to apply this in that situation. In other words, I don't know how to apply this in a situation where the policies that we have, including reimbursement for, it's just too complicated to apply to because so much happened before that I don't know that my approach would make any sense at that point.
And I would say it's
The European approach to life-saving drugs is to do price referencing. There's some price referencing that is
And the public authority can set, that was the community of justice thing, included the public authority And this is a situation where if we deemed life-saving drugs to be in the public interest for the common good, then there would be basis for having the public authority set a price. But we've done it this cockamamie way, so I have no idea what the right answer
And,
is.
yeah, I was gonna say, this is an interface between contract and property, because so long as we've given this really broad, really long property or property-like right on the compound, formulation of the compound, that's part of the problem. So, you know, do we need to do that, or do we need to shrink that a little bit, might be part of the answer.
Yeah.
Let's thank our,
We've actually got 5 more minutes.
oh, we do. It says 1 second here.
It was 1 more second that we had on contracts, and then we shifted to David, and we're definitely on schedule. A lot of the discussion has been about what I would, of contracts has been about what I would call efficiency, and David Opterbeck, you know,
Right.
threw out the notion that, or suggested, I think, that that's not a Christian concept.
I didn't quite say that. I said it's not, efficiency is a prudential concern, but I would suggest that efficiency in sort of economic consequentialist terms can't be an ultimate value. So you always have to take efficiency into account. It's a prudential concern, but I don't buy into the, and I do law and economics, but I don't buy into the whole scale notion that this is the way we ought to think about these things.
Are we talking about ultimate values here?
I was.
Okay, yeah.
So this is a question to the people who are having this interchange, which I found really interesting. But, so, as I heard it, the way it seemed to be going is there was this theory about how there should be a conscionability doctrine that would apply when the terms of the contract are unjust. And then when that gets challenged with various situations where the terms of the contract look unjust by reference to what seemed to be the market price, but there seemed to be a good reason to do it anyway, the answer was always, oh, but we can redefine the market so that it's not substantively unjust. And so in the end, I was just kind of wondering, so what is the case that the theory is supposed to apply to?
Well, the hypotheticals that were set up, to which I punted essentially by saying, well, we have to adjust the market, would have to be addressed in very specific terms in a specific case. In other words, there is an artificial shortage, well, the market price will go up. Does it go up as much as particular seller A has charged to a buyer under those circumstances? Well, that's what courts are for. We need facts, and we need a lot of facts. We need a rich set of facts in order to be able to apply the doctrine in any case, even the ordinary stable situation. But if we can, and I don't know what the result will be. I'm not predicting any boom, if you will, in findings of substantive unconscionability. I'm just saying I want a standard by which we can judge whether something is substantively unconscionable. That's as far as I'm going at this point.
I thought the question about the drug is very interesting because, in a sense, when you're dealing with the drug situation, you have the government putting its thumb on the scale.
Yeah.
By opening up, oftentimes funding the research, and then creating a situation where the party that does the research then manufacture the drug and prevent anybody else from making it.
Yeah. For a long time.
Yeah, so they can pretty much, they have the opportunity to do exclusive production of the drug as well as preventing anybody else from doing it. So how would that affect the scale of commerce and price?
Well, yeah, it's just, in our current system, most upstream research is upstream research is done through NIH funding and so on, like basic research. The applied research is mostly done by private pharmaceutical companies. So their argument, of course, is, well, we need the value of the patent because most drugs fail and it costs $400 million or something to bring a drug to market. And there's some weight to that, but that's the way we've set up the system. And the question is whether that's the best way to set up the system.
Yeah, one more question.
Question on the unconscionability doctrine. It seems like you have a one-size-fits-all model. And I'm wondering whether this question that Paul Spear asked about life-saving drugs suggests that there are certain kinds of goods or services that are essential for life or essential for basics of the community, and others that are more discretionary.
Sure.
And does the doctrine of unconscionability have to have various registers of stringency as we think through the moral imperative
Well, maybe, and I'm reluctant to say that because I do think that's the job of the public authority to step in when we are dealing with, public goods for the common good. Then there is scope for the public authority to come in and to regulate the mechanism, including the price. I'm not sure that I think that even with intensive fact-finding by judges, that that's going to be a good solution to that problem. I'd rather see that punted to, with all their weaknesses, the regulatory administration. But I could be persuaded otherwise.
Bob, is there time for one more? One more. In the back of the room.
Scott, when you say that, doesn't that end up undermining the idea of bringing unconscionability back? Because in the well-regulated markets or the ill-regulated markets that we've got in almost everything,
Well,
can you ever find a true market price to measure things against? Doesn't
No.
the regulatory apparatus affect this? Don't the exigencies of governmental policies go into this in just about every market?
well, it's a map. Yes, the short answer to that one is yes, but there's an attenuation.
Market, how do you come up with a pure unconscionable or unconscionable price?
I think it's a matter of degree. That is the attenuation of the involvement of the public authority in these circumstances creating the goods and the services provided in a particular market. And when I buy my iPhone, I don't, or buy my cell phone service, yes, I mean, that the FCC creates that possibility of having the bandwidth available for that. But other than creating the property in which my, my cell phone and data plan can operate, it pretty much steps back. And, so I mean, that's a good point. It's fairly well taken. I should work with that in a way that gives me some better satisfaction than I have right now.
Thanks so much for a marvelous presentation. You're free now.